Sharon? Okay, we are live.
All right, we're reconvening our morning hearing in the House Environment Committee, and we are welcoming John Groveman from VNRC to share with us a little bit of the history of the Clean Water Act and the high points of Act 64. Welcome, Mr. Groveman.
Thank you, Madam Chair. It's great to be here. I know many of you, not all of you. So my name is John Groveman. I am the Policy and Water Program Director for the Vermont Natural Resources Council, or VNRC. I don't know, how much all of you know about VNRC. You're going to see a lot of VNRC people, or a number of them, as you go through your work this year. So VNRC, we were founded in 1972. We're Vermont's largest in-state environmental advocacy group. We were founded, and this would be relevant to the presentation. I'm going to talk about some of the history of the Clean Water Act and its effect it's had in Vermont, and as sort of a foundation, hopefully, to a lot of the work you're going to do. But there was a lot going on in the early 70s. Federal laws like the Clean Water Act, Clean Air Act got passed. Act 250 was passed the same year VNRC was founded. And it was really founded by foresters and farmers concerned about development pressure on Vermont and loss of farmland and forest land. And we were a very small organization back then. We have now 4 programs: the water program, which I lead, a forest program, sustainable communities program that works on land use issues, and a climate and energy program. Just my background, because I don't know a lot of you. Now I'm the Policy and Water Program Director for VNRC. I am a lawyer. I have worked as a lawyer on environmental issues since 1991. I worked for ANR in the mid-90s. I was their appeals attorney and the Act 250 attorney. I was the director of what was known as the Water Resources Board, which I'm going to talk about a little bit, which no longer exists, but used to be the Clean Water Implementing Department for the state. I served in the Shulman administration as ANR's general counsel, and I was the chair of the Natural Resources Board, which does not exist anymore either. It's now the Land Use Review Board. So that's a little bit about me, and relevant to what I want to do today. And I send in two items to be posted on your website. One is a sort of a shortened history of the Clean Water Act, and I did it for the 50th anniversary of the Clean Water Act. Clean Water Act was adopted in, as I said, in 1972. So in 2022 was its 50th year. So I put this together. I teach environmental law at Norwich University. I've been doing that for 10 years. And I use this with my students every year. And it's a good way. I listened to the testimony from Julie Moore and Pete Laflamme and Mike O'Grady. I thought they gave some excellent testimony. And but what I think this does is it kind of tells like some stories about how the Clean Water Act has really had an effect in Vermont, and kind of brings to life, some of the issues. And you could go deep, as I think Mike O'Grady said and Pete Laflamme said. Like, you could have hours and hours and hours of testimony and analysis on any of the issues I'm going to talk about. But I'm just trying to give like a survey of kind of the high points, and it will, I think, reinforce a lot what you've heard from Mike O'Grady and Pete Laflamme and Julie Moore. So with that, I'm just going to launch into it, if that's okay. So 1950s, as Mike O'Grady said, there was a federal Water Pollution Control Act before the Clean Water Act, but it really wasn't. It just wasn't effective. It was not the law we have now, as you heard described by Mike O'Grady and Pete Laflamme. It's a law that involves lots of regulations and lots of permitting. That's not what we had in the 1950s. We had the federal approach really to all environmental issues in the 50s, or before the 70s, when we did adopt all the major federal environmental laws, was really a voluntary approach and money. It was basically the federal government saying, yeah, we recognize that if we have these direct discharges of waste from wastewater treatment plants, that's a problem. We have direct discharges of industrial waste from industrial users. That's a problem. We're not going to make you get permits. We're not going to regulate. But we'll provide money and help to build wastewater treatment facilities. So we did that. We did in the first box in the 1950s, Burlington did have a wastewater treatment facility before the Clean Water Act, and other municipalities did as well. But it was really a voluntary approach from the federal government. And the hope was that really relying, as we often do today, on cities and towns to basically kind of take care of these environmental issues. But in the late 60s, early 70s, that just proved to be a failed approach. And Mike O'Grady mentioned this, the sort of the famous example of what really spurred the Clean Water Act and a lot of the other environmental laws we have is literally the Cuyahoga River in Ohio went on fire. There was so much industrial pollution going into the river that when a fire started on a ship, there was like a slick on the river and it literally went on fire. And, Walter Cronkite covered it on the news. And, it was a lot, there was a lot going on in the 60s. It's funny when I teach this in my class and every year the students get younger and I get older. It's funny how things work that way. But I try to remind them like what was happening in the 60s, the civil rights movements, right? The Vietnam protests and activism around environmental issues, because people did realize it was not right to see rivers on fire. We had, situations like Love Canal, where we saw, the dumping of waste and all the impacts of that. So there was a real motivation, coming from the 60s to have stronger environmental laws on the federal level, that the voluntary approach was not going to be sufficient. The next box I have before I get to the Clean Water Act in 1972 is an example of how what a struggle it was before we had the Clean Water Act to actually deal with these obvious pollution issues. So in 1970, a big environmental issue in Vermont, and the legislature that day, I'm sure I've heard a lot of testimony about it, was International Paper on the other side of the lake was discharging from its paper mill really nasty stuff in its effluent, toxic materials, waste from its paper facility. There's no permit. They didn't have a permit. There's no permitting requirement. We didn't really have any standards for what the water quality should be, but there was pollution. It was obvious. There was odors. People, in the Vermont side was saying we can't swim and we can't boat and we can't fish because of these impacts. They went to then Attorney General Jim Jeffords, and he brought one, he used all the legal powers he could find to sue International Paper. And he actually won. He won a judgment of $750,000 using the sort of the civil laws around nuisance and, civil actions basically to sue them. And I use that, I think it's important to just as an example of just what a struggle it was to deal with what today we just recognize as an obvious pollution issue, right? That is regulated by the Clean Water Act, as I will discuss. And we didn't have to rely on attorney generals like roping around trying to find some legal mechanism to hold a polluter accountable. And $750,000, even in 1970, is not a lot of money. I would say. So it was a success, but I don't think it solved the problem. And I just kind of note in that box as well, as I said, all of the serious environmental problems were beginning to lead to not only federal law changes, but state law changes. And Act 250 was adopted in 1970. And a big part of Act 250 being adopted, the story is that there was failing wastewater systems, especially in ski areas in southern Vermont, and literally failed septic systems and waste rolling down hills. And Governor Dean Davis said this is not acceptable and asked for a solution. And we didn't have the Clean Water Act. We didn't have laws around waste discharges, but we got Act 250. So that was Vermont's way to sort of get ahead of that. I think it's important to note, and I always note this for my students, how bipartisan this was in the 70s. Richard Nixon signed the Clean Water Act. He signed Superfund law. He signed the Clean Air Act. I have to remind my students that Richard Nixon was a Republican. Sometimes I have to remind them who he was even, but I don't think I have to do that here. But and Dean Davis was a Republican in Vermont. So this was a bipartisan issue. We have this crisis. We need to act. So 1972, we act on the federal level to create the Clean Water Act. And so I think Mike O'Grady did a really great job of highlighting the major components of the Clean Water Act that to this day really play a major role in Vermont dealing with its pollution problems. And so the major parts of the Clean Water Act is this permit for direct discharges. So they're called NPDES permits, National Pollutant Discharge Elimination System permits. If you want to discharge from a wastewater treatment plant, from an industrial facility, you need to get one of these permits. They're known as point sources. You heard that from Pete Laflamme. You know, we have this in the Clean Water Act from the beginning. It was embedded this idea that, okay, we have rivers on fire, we have serious problems. We have to deal with what's coming out of these pipes and going into our waterways that are causing these tremendous problems. And we're going to call those point sources, and we're going to require them to get these very strict permits, these NPDES permits. But they also recognized that they thought that that would mostly solve the water pollution problems. But there was a recognition right from the beginning in 1972 that there is also pollution from what are called non-point sources, which is pollution from stormwater. So it's just rain running off of pavement and what we call impervious surfaces. And Julie Moore had some excellent slides about that yesterday. Farm pollution, runoff from farms, carrying pollutants from the farms, you know, to our waterways, and even runoff from logging. So that's in the Clean Water Act. It was written in 1972, but the Clean Water Act weighed heavily on those direct discharges. And I think the hopes of the framers of the Clean Water Act was that if we get at this pollution coming out of the pipe, we're going to get it at the vast majority of the problem. As I will discuss as we go through this, as you've heard a little bit already this week, that has not turned out to be the case. Non-point pollution has turned out to be a much bigger problem that was envisioned in 1972. The NPDES permits are based on water quality standards. So what's in those permits? What has to be in the NPDES permit has to be what's necessary to make sure that the waste coming out of the pipe is not violating water quality standards. And the water quality standards, you know, it's like a 50-page, pretty technical document, but as I think you heard from Mike and Pete Laflamme, really it comes down to the water quality standards have to make sure waters are fishable, swimmable, and boatable. And then there's a lot of technical aspects to make sure that that occurs. But that's basically the bottom line, making sure we don't have so much waste in our rivers, in our streams, in our lakes, in our ponds, that the waters aren't fishable and boatable. And it even set a goal that by 1987, I think, that all waters would be fishable, swimmable, and boatable. We obviously have not reached that goal, but we've improved things tremendously. I mean, I want to stress that for all of the challenges we have today, and we have challenges, the people back in the early 1970s were visionary. They saw these extreme problems. They took action, and you know, we don't have straight pipes of waste going into our waters. I live in Marshfield Village. There's a pipe like on the hill, like below my house. I live right on the Upper Winooski River. That pipe clearly just shooting waste out to the river, like many houses in Vermont or all around the country did at that time. So, but we still have challenges, but I want to stress how much progress has been made. Other key parts of the Clean Water Act, right from 1972, there's a section of the act that basically says that if you want to fill a wetland, it's basically more than an acre. So it's a pretty big amount. So if you want to fill more than an acre of wetland, you have to get a permit from the Army Corps of Engineers. And in addition, if you need one of those Army Corps permits, then the state has a right also to issue a permit for that activity. So that's really important. There was obviously a recognition that, especially all up and down the East Coast, since the Industrial Revolution, there was, you know, you could, whenever you fly, you know, down the East Coast, you could see all the dredging and filling that has gone on. And obviously in other parts of the country as well, but there was the Clean Water Act recognized that had to be regulated, and that there are these significant ecological values in wetlands that were harmed, and you're going to need a federal permit if you're going to have a significant impact on wetlands. Also, part of that same section of the Clean Water Act is there was a recognition if you have to get a license for an energy project, and this primarily dealt with hydroelectric projects. The state also has the authority to issue a water quality permit. Essentially, it's called a certification for that hydro project, because obviously hydroelectric energy it's a really important part of our energy portfolio, and it's definitely energy that can be clean energy, but you're in the rivers, like you're basically using the water in the river. There was a recognition in 72 when the Clean Water Act was created that we do need some review over what impact is taking the water out of the river to make power having on fish, on aquatic life, on swimming and boating, right? So it's the same thing. Like even if you're making hydroelectric power, you need to make sure that the water is fishable, swimmable, and boatable, meeting the same water quality standards that underlie the discharge permits from the point sources.
John,
Yeah.
I have a question too.
Just a quick one.
Head Representative.
Thank you. Was consumable, part of that too, that we drink water?
There's a separate law for drinking water. It's called the Safe Drinking Water Act. No, so it really was that, and that happened about the same time. In Vermont, most of our drinking water, like because Chittenden County is such a large part of our population, Chittenden County, most of those large towns get their drinking water from Lake Champlain. So they need separate permits for that. So they have to treat all those drinking water facilities that take the water from the lake. They have to comply with a whole separate set of laws. So that water is safe to drink. So this is really, Clean Water Act really focuses on this sort of swimming, fishing, and boating, and underfishing is kind of the aquatic, the aquatic life in the water and protecting that.
Great, thank you.
Yeah.
So I have a question for you too. This link, I think this is important for folks to maybe hear again and understand further between the requirement for an Army Corps permit and the state's ability to then also have a separate permitting process. Is that part of the delegation authority, or is it different? Is it a different thing? And do I have that right?
Yeah, so it is really a different thing. So the delegation really is mostly about the NPDES program and the water quality standards. And Pete LaFlamme mentioned identifying the class of waters based upon how high quality they are. So you're protecting them against discharges. Because with wetlands and even the hydro review, states could waive that. They don't have to engage in that review. It's basically giving them the authority to also issue a permit. We're really relying on the feds to issue those Army Corps permits. However, and I'll just jump ahead, Vermont did, and many states have done this, but not all. I don't know the breakdown of how many states, but Vermont has its own wetland regulations and its own wetlands program. And we did
From that.
separate from.
And we don't require the federal authority.
Does not, it's state authority completely, and it operates completely differently than the Army Corps. The Army Corps has a whole different set of rules that it looks at when it looks at these dredge and fill permits, essentially. And we have a wetland permitting system that we adopted in 1989. That's based on the functions and values of wetlands, which, I love wetlands. I'll make the pitch. Like if you don't know, I mean, wetlands, they're incredible. They filter water pollution. They provide incredible wildlife habitat. They host some of our most rare and special natural communities and endangered and threatened species. They have incredible educational value because they're such ecologically unique. And our wetland program recognized all that and basically says you need a permit if you're going to engage in almost any activity in a wetland or a buffer around the wetland. It actually draws a 50-foot buffer zone and says you need a permit to make sure you're not going to harm those functions and values. There are exemptions in our own wetland laws for agriculture, for silviculture, for forestry. But it's completely separate than the Clean Water Act program and operates really, really differently. And I've watched many in the work I've done in Vermont. I think there are issues that the Army Corps doesn't address when it looks at wetlands that we address because we have this sort of ecological function and value approach rather than the looking at the dredge and fill and impacts from the Army Corps. So the programs have worked well together. And as I said, really, if you're not impacting more than an acre, which is very large, you're really not going to get a real review under the Army Corps. And the wetland program, it could be a small activity, recognizing that a small impact could really have a really negative effect on the wetlands functions and values. So we fill a lot of gaps with that program. That because it's not tied to the federal we don't get federal money for that program, and it's not really tied in with the Clean Water Act program. Whenever we have budget tightening, people look to that program, and there's always a fight to make sure that that program continues. And so far, we've always won those fights. But I just, I know that budgets are tight now, so it always makes me nervous. But yeah, so it's a good question. So you heard of this. So the next little box I have is Mike O'Grady mentioned this, and he mentioned it in the context of the dedelegation petition that exists now. So in 1974, the way the Clean Water Act was set up was all the large federal environmental programs operate under the theory of what's called cooperative federalism. There's a recognition that we need these overarching federal standards and protections, but that the states are the ones on the ground and probably best suited to implement these programs for the people of their states. And so they allow states to apply for a delegation to run these programs, to issue all the NPDES permits, to adopt the water quality standards, to classify all the waters. Those are the sort of the core functions of the Clean Water Act. Vermont in 1974 achieved this delegation, which meant we adopted water quality standards. We adopted a program. We hired people to do the NPDES discharge permit writing. We had to show that even though, as I said, non-point pollution, stormwater, farm pollution, logging pollution was not emphasized as much in the Clean Water Act, it is in there. So states need to show that they have programs to deal with those issues. We have those programs in Vermont, and we have that delegation. And so, but the delegation petition that Mike referenced, and I'm sure you'll hear about throughout the session, it's part of the Clean Water Act process. It's sort of an accountability mechanism, right? It's like we have these federal standards. We are going to make sure that every state has to meet minimum standards. So we have swimmable, fishable, and potable waters in every state of the country. And if a state is not meeting its obligations, EPA on its own or a petition could be filed to basically remove the delegation. And it's a way to have accountability. So that's what that's all about. So that's some context for that petition. And you can, if you take that issue up, you'll hear more about the specific issue here. But that was built into the Clean Water Act, and it's really important. There's a couple of accountability mechanisms. Another one that Mike mentioned is NPDES permits have this citizen suit component, meaning that for most permits, only the state can enforce them, or if there's not a delegated state, it would be the federal government. But Clean Water Act permits, and it also applies to clean air permits, and it applies to federal waste management permits. A citizen could sue if it has evidence that there is a violation of these federal laws or permits. You could go to court and not wait for the state to basically take action. And it's proven to be a powerful tool because states don't have the resources to take action about everything. Politics comes into play sometimes, and there's a reluctance of states to take action sometimes. And so you have these citizen suit provisions in these federal environmental laws, including the Clean Water Act. So I think the delegation and the Federal Clean Water Act and the citizen supervision are these really important accountability.
So the citizen supervision was part of the Clean Water Act from its inception.
From the beginning, yeah. Yeah, and I think when I've read a lot about it, and a lot of it was a recognition of the lack of resources all across the country, that you just couldn't rely on states to be everywhere. And EPA certainly couldn't be, right? That's why they want to delegate. Because EPA, so in Region 1, we're in Region 1 EPA, they're in Boston. And, so they're not here. They're not in New Hampshire. I guess they're in Massachusetts. And as you heard from Mike, Massachusetts, strangely, is one of the non-delegated states. And I don't understand why. Don't ask me how it works. I haven't been able to figure it out after 30 years. But
Well, they figured the office was there.
maybe that's it. Maybe that in New Hampshire, they're living free and they're dying. So maybe that's why. But I don't know what's going on out west. But you can see it's very few. It's like 3, right? States want to run these programs, right? And whenever we get into these conversations, the conversation is always, we want to run a program that's by Vermonters for but so I'm gonna skip the next box. So they already talked about it. We adopted water quality standards. So now you're seeing, as we get into the later 80s, you're starting to see. So we've done the major work. We basically build wastewater treatment facilities in communities large and small, right? I live in Marshfield. We have a wastewater treatment facility in Marshfield Village. like a lot of small villages, like I'm sure where you all are from, have wastewater treatment facilities. Obviously our larger communities like, Burlington and the Chittenden County towns and Montpelier and Brattleboro and Middlebury and Rutland, and Springfield, they have wastewater treatment facilities. But we start to see in the late 80s an emergence, like EPA is starting to like peek up its head and say, hey, what are you guys doing about the non-point pollution? What are you doing about stormwater and farm pollution and logging? So first out of the gate, interestingly enough, is in 87, Vermont adopts what are known as the accepted management practices or known as the AMPs, and they've applied to logging. And basically, so the program in Vermont is, and this is how it works with non-point pollution. So, obviously when you have a wastewater treatment facility and waste effluent coming out of a pipe, you could have engineers and scientists treating what's coming out of there. Non-point pollution is diffuse, it's water running off when you're logging, when you're farming, when you build impervious surfaces and you have stormwater. So you have practices to try to control it. And so there's a series of practices for logging pollution. And there are things like put in water bars when you're going up in steep areas and you're logging. And there are things like, you shouldn't open up a certain amount of area to log if you're on a certain steepness of slopes. And, that was, I think, done, EPA was starting to look around all the states and saying, hey, what do you have on the books, to deal with these other issues? Because we made these huge improvements, stopping these direct discharges, but we still have these water quality problems. So I don't think the AMPs have been touched since 1987. It doesn't come up a lot, but I thought that was an important marker, sort of in the history of dealing with water quality in Vermont. So in 1989, another issue emerges, gets on EPA's radar screen that really wasn't in focus when the Clean Water Act was adopted in 1972. And this is this issue of combined sewer overflows, or CSOs. And I don't know how many of you know about CSOs or what you've heard about them, but basically, one way of dealing with stormwater in the years where we built out all these wastewater treatment facilities. So as I said, stormwater was part of the Clean Water Act, and there was a recognition that something had to be done about it. Communities, municipalities had an idea that was, logical, that said, hey, what if we directed the stormwater to these wastewater treatment facilities? And that way it wouldn't just run off into our rivers and streams and lakes and ponds and cause harm. It can go through the treatment plant. It can mix in with the effluent, with the wastewater. It can all be treated and we'd have better water quality. And that turned out mostly not to be true. And now with climate change and the intense rain events we get all the time, and then the horrific, flooding events that we see now, like 2 Julys in a row that we've had. And, you could go back to Irene and further on the extreme flooding events. But what's happening is way too much stormwater is getting into these plants. Those plants were not designed to treat all that water. And so what happens is when you have these events, water has to be released from the facility, and sometimes it's partially treated sewage or not treated sewage at all. And obviously that causes significant acute water quality impacts the minute all of those pathogens are released. Again, the goal of the Clean Water Act is swimmable, fishable, boatable. Certainly right after those events, you don't want to swim or fish or a boat in those waters. We have 13 facilities in Vermont that still have CSOs. In 1989, EPA adopted a CSO policy. And basically the policy is you need to phase these out. There was a recognition that it would be, we built these plants to accommodate the stormwater. Maybe that was a mistake. We are going to give time to communities to sort of have a plan and raise money and have capital projects to really, the best way to deal with it is to not direct the stormwater to those facilities anymore. But they're very expensive projects. Of the 13 facilities, most of them are our largest communities in Burlington and Middlebury and Rutland and Brattleboro and Montpelier. I have a list I could show you. And what's disappointing to me is that 1989 was EPA adopted the CSO policy that was supposed to start the phase out. And we're sitting here in 2025. And we haven't phased out CSOs in 13 of our facilities. VNRC over the last few years has done a lot of research on this. We actually appealed the Rutland NPDES permit because we didn't believe that the conditions in that permit met what the the CSO policy, and later on, it's in my timeline, EPA did adopt a CSO rule. And we did, basically our position is we need to, obviously, we're not going fast enough, like too much, this is taking way too much time. And EPA and its CSO policy really envisioned that within 5 or 10 years, CSOs would be eliminated. And now we're sitting here more than 30 years later. So recently, VNRC submitted comments on the Middlebury MPDS permit. We commented on the Montpelier MPDS permit. And we're, looking at responses to those comments. And our goal is to expedite these plans and the phase out, because it's just clear to us that it's taking way too long. So that's an issue that's come up in the legislature over the last several years, but hasn't gotten a lot of focused attention. We're working also on a report that we hope to issue this spring to really explain the federal policy on CSOs, the state policy, the CSO problem in Vermont, and make some recommendations on how we could do better on that issue. But
So my understanding, though, is that since we adopted our own Clean Water Act in 2015, that it has accelerated the pace of addressing them. Is that accurate?
things have gotten a little bit better. Yeah, I mean, but it's still really, so like I look at the Montpelier permit, and the Middlebury permit and the Rutland permit, and there's no end date, for so I think some of the facilities, yes, and the plans are better, but they don't have any, there's no date in any of, in those plans and some of the others that say, well, when could we expect the CSOs to actually be abated? And, we think that, the conditions, there are really almost no conditions in the permits that are pushing this along. All this work is kind of happening outside of the Clean Water Act and the permits. But yeah, so things have gotten a little bit better, but yeah, I saw there was a hand up.
I think, Sarita, did you have it?
Just real
Representative
quick.
Austin?
So would the sewage and the stormwater need to be treated differently and then discharged as a solution? Or does the stormwater what happens to the stormwater?
So Burlington's a good example. So Burlington also has CSOs, but what they've done is they are requiring for new development and even for existing development to basically reduce the stormwater coming off their property, like to basically try to have it infiltrate into the ground or keep it on the property. There are other they're now part of the Clean Water Act, and some of you may know this from your work in your municipalities. There is a requirement for some of the larger municipalities to have municipal stormwater permits. They're called MS4 permits. And Rutland has an MS4 permit, and Montpelier doesn't. Like it's a small community. I think there should be more. So when you have an MS4 permit, and Burlington has an MS4 permit, you could use those permits to basically try to create stormwater control mechanisms for the municipality to basically control stormwater, but don't send it, to the wastewater treatment facility. Or the other option is to increase the capacity in the wastewater treatment facility. I acknowledge it's very expensive, and that's why EPA in 1989 didn't mandate. And I think one of the misconceptions, and this is one of the reasons I started to do all this research, because people would call me up and say, this has got to be illegal, right? How is it legal that when it rains, like you have raw sewage or partially treated sewage discharge? And I said, yeah, that doesn't sound right to me. But I did a lot of research, and I found that going back to 1989, EPA said, we're not going to say that's illegal as long as you have a plan and you're phasing it out, basically. And my concern is that it's just taken away. It's really lagging along. So I understand what EPA did in 89, because if they made it illegal, I mean, you'd have a lot of illegal discharges that we can't stop, right? Because we're not going to shut down wastewater treatment facilities. So
is that why we're hearing from constituents about the 3-acre?
No, separate things.
Separate.
We will get into that. Representative Tagliaferri.
Can you name the two major hurdles to the not having the development or the expansion of these sewage treatment plants to be able to handle it?
So the major hurdle is money. No question about it. But I think the other major hurdle is the plans in 1989, when EPA set out this policy, we're developing long-term control plans for some of these facilities just in the last few years. So I think another hurdle is why did we just didn't act in a serious way back in the early 90s, in the early 2000s, you know? So I think there was just a lot of foot dragging maybe because of the money and because it's difficult. But I think we're trying to daylight this, you know, and say, where are the most serious problems? How do we raise money? We've had, and part of the success that the chair mentioned is yes, the Vermont Clean Water Act from 2015, but also the infrastructure money and the COVID relief, the ARPA money. Like we did have this infusion of money. And a chunk of that money was used for some of these CSOs, and that's great. But we just need to get real that we need to either work with the feds, like, you know, no state, and including Vermont, obviously could afford to do this on our own. But I think it needs to be more of a national priority to provide money to fix these systems now that we're, you know, more than 30 years down the road, you know, from when we identified that this was a problem. So I'm just gonna keep going. Is that all right? So 93, as I said, we're entering this era where we're thinking more about issues that are other than the NPDES issue, logging, pollution, CSO issue. In 1993, we get our first MOU memorandum of understanding between the Agency of Agriculture and ANR about dealing with farm pollution. So that becomes an issue. Again, I should have mentioned, I think Pete mentioned this, to make sure that we're complying with the Clean Water Act, there's a lot of monitoring that goes on all over the state, right? The Clean Water Act requires that every 2 years, every state monitor all its waters to make sure that they're meeting the water quality standards, actually in stream, in river, in lake, in pond monitoring. And that monitoring was showing problems. And the problems were not from the point sources. They were from stormwater pollution and farm pollution in particular. So I think in 93, you know, at the prodding of EPA, there's like, hey, states, including Vermont, you need to do more on this. So ANR and the Agency of Agriculture start working together on trying to deal with this farm pollution issue. I'll kind of jump ahead, and then in 1995, we get our first version of what were known as the acceptable agricultural practices. And there's sort of a companion to the AMPs for logging. And like I said, you're not regulating discharges from a pipe, but they're saying farmers have to implement practices to better control farm pollution. In 2015, when we adopted the Vermont Clean Water Act, we changed those again to the required agricultural practices that we had today, because it was a recognition that the memorandum of understanding between ANR and Ag, the acceptable agricultural practices, the AAPs, they weren't sufficient. So we have now the required agricultural practices. They're more stringent than the AAPs. There are several permitting programs at the Agency of Agriculture for medium farms and large farms in particular. And there is a small farm program that could be brought into that permitting program. And the state, the Clean Water Act really says that you have a farm of a certain size and you're discharging, you need a Clean Water Act permit. They're called CAFO permits. They're concentrated animal feeding operations. That's really the subject of the petition of the EPA, is that there are farms out there that should be under the Clean Water Act that are not, because they're the RAP, Required Agricultural Practice Program, those other permit programs I mentioned, an Agency of Ag, the medium farm permit program, the large farm, they're not run by ANR and they're run by Ag. And when there are discharges from farms that really should be under the Clean Water Act, that'll have more stringent requirements, and those citizen suits, right? The accountability that goes back to the accountability that the Clean Water Act provides. We're not getting that. And so that's really a big part of the petition when you hear about the petition that's going on. And we still struggle with these issues, obviously, to this very day.
Representative Pritchard, yeah.
So how many CAFO permits have been issued since?
In Vermont?
Yeah.
0.
Why is that?
Because this is part of the issue with the petition, that farmers have been under this other sort of system of regulation from the Agency of Agriculture. There are a number of farms that have large farm permits that include water quality requirements. There are a number of farms that have medium farm permits. We believe, and we were part of, I should say, the petition was filed by the Conservation Law Foundation, the NRC, and Lake Champlain Committee. We all filed the petition together. And the petition, one of the main concerns is that there are clearly, we did a record review and we found that there are farms that are under that other system that should be under the CAFO system, and they're not. And EPA actually, in their letters that they have written in response to the petition, has agreed that they saw the same thing. There should be some CAFO permits in Vermont, but there just has not, farmers has not been, A&R has not forced them to come and get the CAFO permit. And our records show that there was a back and forth between the Agency of Agriculture and A&R, where the Agency of Agriculture really resisted bringing those farms into the CAFO permitting program. And there was a tussle, like an interagency tussle. And so I think a big part of the problem is that this dual system of regulation, and A&R just hasn't, they have the legal authority and they actually have a legal requirement to do it, but because farmers will say, hey, we're going over here. We're not going to go over there to A&R, and the Agency of Agriculture, I think, supports that. They would like to keep farmers out of the Clean Water Act permitting system.
Where do you think it should be?
I think it should be under A&R. I think it should be clear. It should have one permitting system that is the system all over the country that could have very, somewhat stringent, but very similar standards that we have now. But the key would be A&R would be doing all the inspections and all the monitoring and all the enforcement of those programs. And that's what, and if you look at EPA's letter, read the EPA letter, they haven't made a final decision, but they're indicating that they have the same concerns that we do, that there are farms that should be under the Clean Water Act system and they're not. We could do like hours and hours, and I think you'll want to take this issue up, and EPA has not, like, we're still working through the process with EPA. There's not a final decision with EPA.
When, since we're on this topic,
Yeah.
when would a final decision be expected?
Yeah, it's a good question, and made more difficult by the transition that's happening in the federal government right now. We had a meeting with EPA just this week. The A&R has proposed a response to EPA's, the concerns that they raised that were based on the concerns in the petition. We don't think that A&R's response goes far enough. EPA hasn't weighed in yet. I think within the next few weeks, we should get a response from EPA, and then we're gonna have another meeting to talk about it. Hopefully, I would think the next few months. And then we'll have to look at how everything resolves, we, the petitioners, and all the parties, and decide, like, if there is legal action that could be taken if any party doesn't agree, with EPA's determination. So I think we should hear from EPA within the next few months. As a guess.
Representative Austin, did you get your question answered?
So let's see, what else I want to highlight here? I want to talk a little bit about hydro issues. So really, Vermont, this is something that doesn't get talked a lot about, but in 1994, so we used to have the Water Resources Board. We had an interesting system that has been changed over the years, but in 1974, when Vermont was delegated, A&R was much smaller. It was a much smaller agency. They didn't have the number of scientists, and they had one lawyer there, which maybe that was a good thing. Now they have 10 lawyers. We could argue about that. But and it was in this tradition of, Vermont having these citizen boards, right? Act 250 was a citizen board. We had a citizen water resources board, and that board adopted the water quality standards that's underlying, the NPDES permit program. That board adopted the wetland rules. The agency staff at A&R issued the wetland permits, but the board adopted the wetland rules. It was a really powerful and important board, and it heard appeals of A&R water permit decisions. And there was an appeal in 1994. There was something called the Lamoille Hydroelectric Project. One dam part of that project is the Peterson Dam in Milton. And it was one of the first cases in the country where I think it was VNRC, but well before my time. I was still living in New York City then, so I was not even here then. But basically argued that you couldn't issue a license, that the dam didn't meet the water quality standards because it was basically destroying historic salmon run that VNRC had evidence of, and the Water Resources Board agreed, and basically said, we are not issuing a water quality certificate for that one facility. I think there are 4 hydro facilities part of that project. It was one of the first times that you got a decision from a state board, a water board, or any entity saying that a project didn't meet the water quality standards. And it really, and an important part of that decision, which relates to this day, as we have these issues of hydro projects being either proposed, there's a couple of like projects being proposed, but mostly they come up for relicensing every 30 or 40 years. Could you consider economics? When that decision was made, the hydroelectric company, which at that time was CVPS, which doesn't exist anymore, said, listen, we can't afford to like not run the dam the way we say, and you have to consider that. And the Water Resources Board said, no, the Clean Water Act says you just basically look at the water issues and the water impacts, and you're not gonna, these waters won't be fishable to the point that they should have a salmon run it was being really destroyed here. And it really set an important precedent that you don't look at economics in these hydroelectric permitting decisions, and how powerful the water quality standard review is, these hydroelectric projects. And as our energy situation, becomes more complex and we're trying to get off of fossil fuels, these issues continue to come up. So I just wanted to highlight that.
Can you just, for a minute, flesh out a little bit more about the Water Resources Board? You mentioned were you the chair or you were on
I
it?
was the executive director.
Okay.
I was like the staff.
You were paid, but it was a volunteer group, but you say about how many people were on it? And I guess I'm wondering if you can characterize their background, like
It was a 5-member board. They got paid a per diem. That was what they got paid.
$50 back then.
Yeah, it was $50. I was a director. We had 2 lawyers, and we had an administrator who helped us with our administrative needs. And that was what we had. It was a point of, after going through what you did with the Land Use Review Board, there really weren't I think what you did with the Land Use Review Board, is a model, because I think it worked out okay, because the members were appointed by the governor. The governor tried to look for people with, water quality background, engineers, people at UVM had been on it. Always like one environmental lawyer. We had John Roberts on it for a long time. He was a farmer and very still much involved in water quality issues. I think he worked in the Biden administration for USDA, and he worked for the Addison County. You probably know him, one of the farming organizations. So it was people, that was the type of people, but there was no requirements like there are now, which I really, I think what he did with the Land Use Review Board is say you have to have certain qualifications. But I think it worked out. Because I think the governors that appointed people, they looked for people with that expertise. They were thoughtful people, and it was a big deal. Like when they issued that decision, they knew it was a big deal, and they didn't have any technical staff, but they did rely. We had proceedings where the agency would testify, and this hydro and whoever the permit applicant was or the appellant would have experts testify, and then they made their decision. But that is just a bold decision. Later on here, and I know I'm running out of time a little bit, another decision that the board made toward the end of its existence, in 2001, and this is just another example of the non-point pollution coming to the fore, was decisions around stormwater. So there were these cases in 2001 where there were challenges to some of the development in Chittenden County. It was the Hannaford and Lowe's that does exist now on Route 7, just like when you get off of I-1 and 89, and that was discharging to a stream that's a tributary to Lake Champlain that didn't meet water quality standards. State did its monitoring every 2 years, said it doesn't meet water quality standards. Why doesn't it meet water quality standards? State has to say that stormwater. And so environmental groups came in and said, you can't issue a permit to add more stormwater to a stream that doesn't meet water quality standards because it's polluted with stormwater. And the Water Resources Board agreed. And it's kind of sent shockwaves through the Vermont legislature at that time looking for a fix. Well, what do we do? How do we get people permits? We have to have development in county is our growing area. We put a system in place as a result of that decision that said you couldn't have a net increase in stormwater. So people had to get offsets to basically for that project, and Hannaford Lowe's was able to get an offset. So they were able to say, we won't increase the stormwater going to that stream. Then ultimately, because it's under the Clean Water Act, when you have waters that don't meet the water quality standards, and you've heard about this with Lake Champlain, which doesn't meet the water quality standards because of phosphorus, and we have the Lake Champlain cleanup plan, which is known as the TMDL. We developed TMDLs for a number of Chittenden County streams, including the one at issue with Hannaford Lowe's. And now that we have those cleanup plans, they can get their permits because they have to be consistent with those cleanup plans. That was a huge decision the Water Resources Board made. I think I was with the board at that point when they made that decision. And then we knew it was controversial, but we thought it was the right decision. I think history has shown that it was the right decision because we ended up getting cleanup plans for all these waters and stopped just issuing permits for development that was making polluted water situations worse. I do think that led to, and again, this goes back to the great work you did with the Land Use Review Board. I think people wanted the board eliminated after that because there was frustration with that decision and its impact on the regulated community and the business community. We got through that, go down Route 7, there's plenty of development on Route 7 that hasn't been shut down. It was, I think people, it was one of the things that moved all the appeals to the court, which we have today. And you can say the same thing about Act 250, that environmental board had made enough decisions over the years at that point that some people didn't like. And so, well, let's try something new, basically. But I think it was a great decision. I think both those decisions are examples of citizen boards that had experts on them that developed real expertise and made really difficult decisions, but follow the law, follow the Clean Water Act. And yeah, so I don't know. I can go on about the board way more. So I'm going to try to wrap up here. I'll wrap up. You could read the timeline yourself, but I guess I'll wrap up with kind of getting to Act 64. And it's a good segue out of the story I told about Hannaford and Lowe's. And Councilor Grady could tell you stories about the stormwater laws that we rewrote after the Hannaford and Lowe's decision if you really want to hear more about it. But in 2015, similar issues, the Clean Water Act says if you have water that don't meet the water quality standards, you have to have the cleanup plan, the TMDL. We had a TMDL, I think, going back to 2002. It wasn't working. It didn't have specific enough actions to show how we were going to basically reduce the phosphorus in the lake. CLF raised that issue as well as climate change was not factored into the calculation of how much phosphorus needed to be reduced. And so in 2015, there was a basically revised TMDL that was issued with new targets, specific actions that must be taken to reach those targets, and an accountability framework that there's check-ins constantly with EPA and review to make sure that we're on track. Pete Laflamme, he said something like the Vermont Clean Water Act, it kind of went hand in hand with the revised TMDL. I think really, my recollection is it was adopted because we were required to take that action so EPA would basically say Vermont had a valid cleanup plan. So the requirements in Vermont Clean Water Act, if we want to change any of them, you'd have to go back to EPA. They're relying on all the pollution reduction that we're going to get from we increased the type of projects that need stormwater permits, including the 3-acre. This is where the 3-acre issue comes up. So that's where that came from. We said, okay, we've got these old systems that don't meet modern stormwater controls, may not have any stormwater controls. They need to be come up to modern standards to the extent that's practicable and feasible so we can get that reduction of pollution. We need the required agricultural practices because we need to get more phosphorus out of farm pollution. We need to, we looked at NPDES permits going back to where I started this. I think the most obvious and clear success of the Clean Water Act has been the direct discharge and the non-PDS permits. When it comes to phosphorus, I think there was general agreement that like you only squeeze so much more phosphorus out of those pipes. Saying like we did ratchet down on the amount of phosphorus that could come out of those pipes, but to go lower it's so costly that the cost benefit isn't there. And the problem, as analyzed by ANR and by EPA, is that really the focus should be on stormwater and farm pollution to get, to meet the phosphorus targets that we have. But the point I want to make and then the last thing I'll say is the other document that I handed out was op-ed that I wrote about clean water being tied to the economy. And I wanted to remind myself and everybody else that when we went through the Vermont Clean Water Act, there was a really great coming together. Again, it was very bipartisan, and it was this all in. Like it was this recognition that if we're gonna meet this challenge, we all have to be in. We're asking municipalities and their wastewater treatment plants to upgrade and meet the phosphorus standard, which was much more stringent than it was before. We're asking more of developers and landowners and municipalities to deal with stormwater, and we're asking more of our agricultural community to deal with farm pollution. And it has to be every sector, and we all need to make a commitment, and we need to put our money where our mouth is. And part of the state's commitment to EPA was to create a clean water fund to help fund this work. And we did that. We created a clean water fund. It took us, a couple of years after 2015 to find the sources of revenue and establish it. But we did. And we have that fund today. And is it enough? I'm sure it's not. But we need to really protect that money. And I'm really proud of what I remember happened in 2015. And, not only were we all in to clean up Lake Champlain, but it was a recognition. Like Julie Moore mentioned it. Yeah, I couldn't agree more. The tourism dollars, I cite some of the statistics in the op-ed I wrote. You could have people from ACCD in. Tourism is so important to Vermont's economy. We need a clean lake if we're going to have a good economy and have people come here and enjoy Vermont. And we have many other aspects of the Vermont economy, but the environment and the economy is really linked in Vermont, and that was really recognized in 2015. And I don't think anything has changed. So you could read the op-ed. It's just kind of reminding, like I said, me and everybody else, I think, about that. We haven't talked about it as much as we've been tackling other challenges really since 2015.
Great.
So thank you for giving me this time, and you guys are much better than my students when I go through this by a lot.
I'm wondering how many lectures you compressed for us today. That was really great. Obviously, we could continue even diving into the timeline you've given us, but we need to move on.
Yeah, well, thank you very much. I really appreciate it.
Well, I'm sure we'll have you back.
Yeah, I hope so. Thank you.
Thanks so much, John.
Post the op-ed
Can we post it?
on our web.
I'm not sure. Let's talk about that in a minute. I want to, out of respect for our legislative council's time and our own needs, let's take a 5-minute break, but please come back promptly. And then we're going to just check in with our legislative council. I'm not.
Op-ed that he wrote.
Yeah, so the link is on.
Oh, it is on there.
Yeah, it's a link. You have to scroll down.
Right. Oh, I know. It's the link.
Yeah.
Should I refresh it, you think?
Yeah, because,
It's
Okay.
in the document he
yeah, in this doc.
provided for us first.
But you don't.
Oh, I see. Okay, I have it. Thank
Okay.
you.
To go into a document to get a link to the other document.
Yeah.
You doing window open?
Ellen, how are you?
Lovely to see
Lovely today. Uh-oh.
you. I mean, I'm doing
You doing?
busy right now. I'm like very in demand for some reason.
Hey.
Hello. Nice to. How are you doing? I got this. Yeah, they're pretty.
So.
Yeah, I'm regularly these. Thank you. It's a waste of it. It's been,